Hello friends, today we will start discussing about the Constitution of India. It's a very important topic for the Indian polity and every Indian must know something about the Constitution of India. So in this lecture today we will be looking at the salient features of the Constitution of India and the nature of the Constitution of India. So this knowledge will help us in preparing for civil services examination and also at it will help you in school and college education as well. So let us start. So have you ever wondered how the name Constitution came to be given to the particular book? So interestingly, it is written in the Article 393, short title, and it states that this Constitution may be called the Constitution of India. So it is the Article 393 that has given name to that book as the Constitution of India. So technically, this is how the Constitution of India got its name. Then the very next article, Article 394, it talks about the commencement. And if we read this article, then there will be no doubt in our mind that the commencement of the Indian Constitution is 26th of January 1950. This article reads that this article means this article 394 and article 5, 6, 7, 8, 9, 63, 24, 366, 367, 379, 380, 388, 391, 392 and 393, all these articles, they came into force at once in the beginning, and the other articles of this constitution, they came into force from 26th January 1950, which is referred to as the commencement of the constitution. So there should be no doubt in our mind that 26th of January 1950 is the day when the commencement of the constitution took place. It's written well in the constitution itself. So this is about the name and the commencement of our constitution. So the very basic question is, what is constitution? So constitution is defined as the fundamental law of a nation. Fundamental law means all other laws, they are derived from the constitution, and no law can be made which is going against the ethos of the constitution. So every law that is made in India must confine itself to the Constitution of India. Okay, so Constitution is the fundamental law of the nation. It is the supreme law of the land because every other law is derived from it, and Constitution is the supreme law of the land which takes shape in the Parliament of India. Constitution is a document, or it is a set of documents. It is a document or it is a set of documents which provides what? Which provides the basic rules that allow coordination amongst the members of the society. So whenever people come together, they form a group, they form a society. So they feel the necessity to have some sort of rules and regulations that will be binding themselves together so that there will not be any conflict. And if at all there is conflict, there must be a successful resolution of the conflicts. So this constitution is a document that provides the basic rules which allow coordination among the members of society. Without constitution, there would be no coordination and there would be chaos. Therefore, whenever any country or any nation gets its formation, the first thing they do is they write their constitution. Okay. Then it is a document which provides a body of fundamental principles according to which the state is constituted or it is governed. So okay, a country comes into conception, country comes into being. But how to rule the country? The Constitution provides the fundamental principles based on which the country is governed. Okay, so the principle may be fraternity, equality, justice. These become the fundamental principles. Then Constitution is also a document or a set of documents that limits the power of the government. You see, a government comes into existence and the people give enormous powers in the hands of the government. But should that government be limitless, or should that the government itself be within the limits so that it does not transgress its powers, it does not go beyond the constitution? Therefore, the constitution itself limits the power of the government in many ways. So this limitation of the power of the government is what is called as constitutionalism. So if the question is what is constitutionalism, it's simply the limitation on the power of government. Otherwise, there would be anarchy. Otherwise, there would be autocracy, dictatorship. So in order to avoid dictatorship, there must be limitations on the power of the government. And this is what the constitution is meant to provide. And this is called as constitutionalism. Then the constitution is a document which expresses the ideals and aspirations of the society. Okay, what the society together aspires to achieve. It aspires to achieve, for example, equality, social equality, economic equality, political equality. So these becomes the aspirations of the society. So it constitution provides the ideals and aspirations of the society that we'll be looking in detail in the forthcoming lectures. So this is the basic idea what a constitution of a country is. Okay, so let's move forward. What does the constitution express? It expresses the fundamental identity of the people. How do the people identify themselves in a country? The constitution, it expresses the collective identity. We saw that when a society is formed, for the coordination in the society, constitution is necessary. So constitution expresses the collective identity. It comes into being only through the basic constitution. Collective identity is obtained when we have a constitution. Otherwise, there would not be a collective identity. A country as a whole is identified by its constitution. It gives political identity. How? By agreeing to certain basic norms and principles. We said that for the governance of a country, certain basic principles are required, and those principles are found in the constitution of the country. It provides political identity by that way. It also provides moral identity. Morality is what is right and what is wrong. So we may not do those things which are wrong, we may do those things which are right. So the constitution for the country as a whole provides authoritative constraints, limits over what one may do and what one may not do. So it provides a moral identity as well. And overall, it provides a national identity wherein it relates to the relationship of nation with the states or center with the states. It's the relationship between different regions, means different states in a nation, and the central government. So it's basically the relationship between the center and the states, if we take example of India. So all these identities, they form fundamental identity of the people, and that is expressed in the constitution of any country. So this is in nutshell what a constitution is about. It's a fundamental law of the nation which expresses the different types of identities: collective identity, political identity, moral identity, and national identity. It is a living and an organic thing. An organic thing means it can be amended, it can be molded to adjust itself to the situations. So if the situation changes, if the necessities of the prevailing time changes, then the constitution is amended accordingly, and by that way it becomes an organic things, which it becomes a living document. This is what the Supreme Court of India had stated in its judgment Goodyear India versus State of Haryana in 1990. So this is what a constitution is. Now let us move towards what are the salient features of the constitution. Okay, these are in nutshell the salient features of the Constitution of India. The Constitution of India is the lengthiest written constitution in the world. See, it is a written constitution. We saw it is a book which will be called as Constitution of India according to Article 393, and that written constitution is the lengthiest constitution in the world. Okay, it has a chapter on fundamental rights. Fundamental rights are those rights which are written in the constitution itself. They are the basic rights which every citizen gets by virtue of the constitution itself. It also provides fundamental duties. Like fundamental rights, there are also fundamental duties given in the Constitution of India. It provides for directive principles of state policy. It means how a state is going to formulate its policy. There must be some principles to guide those. India is a welfare state. So the state, they shape their policies in such a way that welfare of the people is achieved. So to achieve that welfare, there must be certain principles. The constitution itself provides directions that these must be the principles which you must apply while formulating your policy to get the desired result, to achieve our aspirations and our ideals. Okay, then it provides for single citizenship. We may be from different states, but we have one citizenship, that is we all are Indian citizens. Unlike in USA where there is dual citizenship, citizenship of the United States as well as citizenship of particular state or province. But in India we have single citizenship. Okay. Then it provides for universal adult franchise. It means the voting rights. In India, voting right is given to any citizen who has achieved 18 years of age. So it is a universal. Hereby we get the political equality. Every person has got only one vote. So he may be rich, he may be poor, but he has only one vote. So there is universal adult franchise. This becomes a salient feature of our constitution. Then it provides for integrated judiciary and it provides for an independent judiciary. So judiciary is not dependent on parliament or on the executive, that is the ministers. Judiciary in itself is independent. So we have an independent judiciary, that is a salient feature. At the same time, we have an integrated judiciary. It means that we have a Supreme Court at the center, we have high courts for different states. And these Supreme Courts and high courts, they are organically linked together. The administration is linked together. Supreme Court is the apex court which governs all the other courts in India. And high courts take care of the particular region, particular states, and some high courts they have jurisdiction over states plus union territories. Okay, so there is an integrated judiciary, Supreme Court plus high court plus district courts, and the administratively they are organically linked, but they are all independent from the other organs of the state. There are three organs of the state: parliament, that is legislative, then the executive, that is the ministers, and the judiciary. So all judiciary is a independent organ, whereas what we see is that the ministers come from the legislature. So there is a fusion between legislature and executive in India, but judiciary is altogether independent. Okay, so this is the meaning of independent judiciary and integrated within itself. The administratively Supreme Courts, high courts, and other courts are linked together organically. Okay, then in Indian constitution there are provisions for emergency. We have three different kinds of emergencies: national emergency, Then whenever there is breakdown of the constitutional machinery in the state, which we commonly call as state emergency. And then there is financial emergency. These type of emergencies are written in the constitution itself. Then it provides for Panchayati Raj, which means local self-government. So at local level, the people are given the power to govern themselves. So local self-governance is an important feature of the Indian constitution. So this Panchayati Raj, the constitution was amended in 1992 to provide for this structure for Panchayati Raj. Panchayats in the villages and municipal corporations and municipal councils, the urban local bodies in the urban areas. Okay, so all these things are to be studied in detail when one tries to study about the Constitution of India for any examination. Okay, so these are the salient features broadly. And one of the important salient features is that we have derived our articles from various sources. So it is a fusion of various sources. We will be looking at the different sources in today's lecture. Okay. So when we say that the Indian Constitution is the lengthiest constitution in the world, which is written constitution. By written, it's very clear that it has been written in the form of a book or document or a set of documents. Then it is the lengthiest in the world. Why? Because it has got so many articles. The original constitution of 1949, it had 395 articles. It had 22 parts and it had 8 schedules. Now there were many amendments since from 1952 to 2021. There were many amendments. More than 100 amendments have been made to the Indian Constitution, and presently the number of articles have increased and they have become around 469. This figure may change, okay, but we have quoted it from a standard book. Then there are 22 parts: part 4a, part 9a, part 9b, and part this 14a. They have been added. We'll be seeing what these parts are, and part 7 has been deleted. Okay, this part 9a and b, they relate to the Panchayati Raj. Part 4a relates to the fundamental duties. They all have been added to the Constitution of India. And then 8 schedules were there initially. 4 more schedules were added, and today we have got 12 schedules. Okay, so 9, 10, 11 and 12, these are the schedules that were added. So when we study about the Constitution of India, we need to know about every schedule, what it talks about, and we also need to know about these new parts, what they talk about. Okay, so if we compare the number of articles of the Indian Constitution against the constitution of different countries, we will find that we are the lengthiest. Why? Because in USA there are only 7 articles. In the Constitution of Australia there are 128 articles. In the Constitution of China there is 138, and in Canada there are 147 articles. So clearly we can see that the Indian Constitution is the lengthiest written constitution in the world. And we have got a written constitution, no doubt. In United Kingdom there is no written constitution. Okay, so therefore this written becomes important. Now looking at various sources, we said that Indian Constitution has taken its articles from different sources. So the structural part of it, how the articles have been given a structural framework, that has come from the Government of India Act 1935. The British, they had enacted this Government of India Act 1935, and out of our original constitution that had around 300 and something articles, 250 provisions were taken from this Government of India Act. So it provided the structure, the framework for the Constitution of India. So it becomes a very important act because so many provisions were taken from this act. Then the philosophical part, it was taken from USA, then Irish Constitution, and also from the USSR. We took fundamental rights. The ideas of fundamental rights came from the United States of America's Constitution. The directive principles of state policies, they were taken from the Ireland. Likewise, fundamental duties, they were taken from the Constitution of the USSR that time. Before Russia, it was USSR. And the political part, it was taken from the United Kingdom. Means what form of the government we have, the relationship between the legislature and the executive. So United Kingdom was, England was the country that had ruled us. So we were already accustomed to the kind of governance that the British had been imposing over India. So that was continued by the founders of the Constitution. So political part was taken from the United Kingdom. So broadly, structural parts come from the Government of India Act 1935. The philosophical part comes from the USA, fundamental rights. Their directive principles from the Ireland, fundamental duties from USSR. Political part has come from the United Kingdom's Constitution. So because Government of India Act 1935 is important, what all the features we got from Government of India Act that have been enlisted here? We got a federal scheme from the Government of India Act. Federal schemes means we have got three lists. In the seventh schedule, we have got the central list, the union list, then we have got the states list for the states, and then we have got concurrent list. Okay, so these three lists are there. In the union list, there are certain number of items, which means that on those items the parliament has the power to make laws. All those items that are included in the state list, they have been given to the state legislature for making laws on them. Then concurrent list has got certain subjects on which both the parliament and the state legislature has the power to make law, and in case of conflict the parliamentary law will prevail. So federal scheme means what is the relationship between center and the states, how to govern it. So that the constitution has given a federal scheme. It has given three lists: union list, states list, and concurrent list. So based on these, the federal scheme has evolved, and the scheme has come from the 1935 Act. Okay. Then Office of Governor. This has also come from the Government of India Act. The center appoints governor for every state, and the president appoints the governor, and he also can remove the governor of every state. So this also has been taken from the Government of India Act. Then the idea of judiciary, the structure of integrated and independent judiciary, that has also come from this act. The idea of public service commissions, Union Public Service Commission to fill the posts related to civil services at the central level, and there are many state service commissions. In every state there are state service commissions. So these public service commissions, this idea has also come from the Government of India Act. Emergency provisions, national emergency, state emergency, and financial emergency. So these emergency provisions have also their source in the Government of India Act 1935. And instrument of instructions. Instrument of instructions means they were the instructions given to the provinces how they should rule or govern the subject. So these have become the basis for the directive principles of state policy. The idea of DPSP have come from Ireland. The structure of how the DPSP should be, they were taken from the instruments of instructions. So this relates to the DPSPs, directive principles of state policies. Okay, so this is the source, Government of India Act 1935, and what all the features have come from this act. Okay, so now let's proceed further. What all features have been taken from the British Constitution? So from the British Constitution, we have taken the parliamentary form of government. We have parliamentary form of government. We have a legislature in the state. Then we have Rajya Sabha and Lok Sabha in the center. So we have followed this parliamentary form of government, unlike the presidential form of government which is followed in the United States. We have taken this rule of law, this concept from the British Constitution. Rule of law means law is the supreme thing. No person is above law. So law is equal for everybody. Be you rich, be you poor. You will be governed by the same law. So rule of law, it is enshrined in the fundamental rights in Article 14, and that will be dealt in detail while discussing the Article 14. So as of now, we must know that rule of law is that no one is above law and law is same for all. So there is rule of law in the country. Then the cabinet system. Whenever a government formation takes place, the prime minister in the center, chief minister in the state, they take oath, and along with them they appoint various ministers. So these ministers, some of them are given cabinet rank, and some ministers are given the rank of minister of states. Okay, so those ministers that have that are given cabinet rank, they can be present for the cabinet meeting to take important policy decisions. Minister of state cannot attend the cabinet meeting. Okay, so cabinet system, ministers and headed by the prime minister at the center, ministers headed by the chief minister in the state. Such cabinet system has been given uh, place in the Constitution of India, and it has come from the Constitution of British. Then the legislative procedure, how the law will be made in the legislature, means in the parliament and in the state legislatures, what procedure will be followed to make law. There can be ordinances in case the Lok Sabha, Rajya Sabha is not functioning, the president can formulate ordinances. Okay, when they are in session, when the houses are in session, they will follow a particular procedure to make law. So these are the legislative procedures. They have come from the British Constitution. Then this idea of single citizenship for the entire country, this has also come from the British Constitution. The idea of writ jurisdiction, we saw there is integrated and independent judiciary, and the Constitution has given us fundamental rights. So if any citizen feels that his fundamental rights have been abridged or breached by the state, for instance, state has made some policy which goes against your fundamental rights, so in that case the Constitution provides us the power to directly approach the High Court under section 226 and approach the Supreme Court under section 32, article 32, I'm sorry, of the Constitution, to preserve or to safeguard our fundamental rights. So different type of writs have been mentioned in the Constitution of India, like the writ of habeas corpus, writ of mandamus, writ of certiorari, writ of quo warranto. So these will be dealt afterwards, but it suffices for us to know at this moment that the writ jurisdiction have come from the British Constitution as a concept. Then there is bicameralism. Bicameralism means there are two houses. In the parliament, there is Lok Sabha and there is Rajya Sabha. So there are two houses, and that is the meaning of bicameralism. In some states, in 5 or 6 states, there is a legislative council and legislative assembly. So that becomes bicameralism in the state. But not all the states have two houses. Only 5 states, if I'm not wrong, have got two houses, legislative assembly and legislative council. So that is bicameralism. Then the office of comptroller and auditor general. So this is the office which is in charge for audit of all the government departments and some public sector undertakings. Okay, so it's also an integrated office. So this office of comptroller and auditor general, it has also been taken from the British Constitution. And office of the speaker of the Lok Sabha, it has also been taken from the Constitution of United Kingdom. Then this first past the post system. This relates to the voting, the elections. So in India, majority rule is followed. So out of all the candidates who stand for election, that candidate who gets the maximum number of vote, he is declared as winner. Okay, it's not that he should get more than 50% vote. If 10 people have cast their vote, and if one person has got highest number of votes other than compared to others, he becomes the winner. Okay, so that is first past the post system, where there is no such condition that you should get more than 50% votes. It is only sufficient that you get maximum vote, one vote more than your nearest competitor. That is sufficient for you to become winner. This is the first past the post system. This idea has also been taken from the United Kingdom British Constitution. Now, what all the ideas have been taken from the American Constitution? The idea of fundamental rights. The Constitution of India provides fundamental rights to the citizens, and some fundamental rights are also provided to those who are non-citizens as well. So these fundamental rights have been taken from the Constitution of America. Then this idea of independent judiciary. Judiciary that is independent from parliament and executive, from the legislature and executive. So this independent judiciary is also an idea which is found in American Constitution. The idea of judicial review. We saw that whenever our fundamental rights are breached, we can approach the Supreme Court and High Court, and using the writ jurisdiction, the Supreme Court and High Court can direct the different uh, bodies in the country so that the fundamental rights are safeguarded. Okay, so judicial review is that power which the judiciary has, by the virtue of which it can review the acts of the legislature and the executive. So if the judiciary finds that certain law has been made contrary to the aspects of the fundamental right, then the judiciary can say that this law will be null and void. So that power, by the virtue of judicial review, the independent judiciary in India has got. So this idea has also come from the American Constitution. Then this idea of impeachment of the president, the removal of the president. Impeachment is the word that is used for removal of the president, and impeachment is the word used only for the removal of the president in India. For no other authority, the word impeachment has been used. Okay, in Article 361, the Constitution has provided an elaborate procedure by which the President of India can be impeached or can be removed from his office. So it's a very tedious, a very tough procedure. So removal of the president in India is a very tough exercise which the Constitution itself provides, and that has been sourced from the American Constitution. Likewise, the removal of the judges of High Court, of Supreme Court, and also removal of the Vice President. So the word for these authorities is removal, the word for president is impeachment. So these have been taken from the American Constitution. And the preamble of the Constitution, this idea is also taken from the American Constitution. So preamble is the first chapter, we can say, in the Constitution of India. It is said to be the mirror of the Constitution. Preamble, many of you may have by hearted, many of you may know the entire preamble. Okay, and it's good to know it. So it reflects the entire philosophy of the Constitution in few words. So this idea of preamble has also been taken from American Constitution. And all these words are very important for a person who studies about the Constitution of India. For we need to study about fundamental rights, we need to study about judiciary, we need to study about the appointment and removal of different authorities, we need to study about the preamble while studying the Constitution of India. All these things have been taken from American Constitution. Likewise, from the Soviet Constitution, as we had already spoken about, the fundamental duties have been incorporated in the Constitution of India by amendment. Okay, and in the original constitution there was no chapter on fundamental duties, but later on by an amendment in 1976 it was incorporated, and the idea was taken from the Soviet constitution. Likewise, the idea of justice, social justice, like in the society every person must have justice. So it is because of this idea of social justice that affirmative actions are provided. Economic justice means with respect to the distribution of the resources, with respect to the income, there must be justice. And political justice, it has already been achieved by universal adult franchise. Everyone has got one vote, and every vote has got one value. So likewise, every person is equal so far as the voting rights are concerned, and that has given us the political equality. So there must be social, economic, and political justice. This ideal of justice have come from the Soviet constitution. This we must know. Likewise, from the French constitution, we have got this idea of republic. Republic means the head of the state is elected. Okay, the president of India is the head of the state, and he is elected, though he is elected in an indirect way, but yet he is an elected head. He is not a monarch. He is not a person who has been given that office by virtue of heredity. No, he is a person who has been elected by the people of the country. That's why it is a republic. So French was a republic, and that idea has been taken by the Constitution of India. Likewise, the ideals of liberty, equality, and fraternity, they have been taken from the French Constitution. Liberty, equality, fraternity. If a person studies French Revolution in the history, he will be aware of these terms. So these ideas have been taken from the French Constitution. And as we had seen, that Constitution is a document that provides ideals and aspirations of the people, that codifies the ideals and aspirations of the people. So what are the ideals that we strive to achieve? We strive to achieve justice, liberty, equality, and fraternity. Fraternity means brotherhood. Equality, we saw that we must be equal in different terms: social, economic, and political. And liberty means freedom. Okay, so these are the ideals which the Constitution of India upholds, and it is our duty, the duty of the government as well as the people, to strive for achieving these ideals. Okay, then from the German Constitution we got this idea of suspension of the fundamental rights during emergency. So what happens? The Constitution provides us fundamental rights. It has also provided guarantee that if your fundamental rights are breached, you can approach the Supreme Court and High Court, and they, under judicial review, can even say that a policy is wrong or a law is null and void. But what happens during emergency? If emergency has been proclaimed at national level or state level, whatever, there can be suspension of the fundamental rights. But this suspension is not arbitrary. The Constitution provides a mechanism and principles following which the fundamental rights can be suspended. Which can be suspended, which fundamental rights cannot be suspended, that is a thing which one studies while studying the fundamental rights chapter. Okay, but suspension of fundamental rights, this idea has come from the German Constitution. Okay, we saw that the idea of emergency was taken from the Government of India Act 1935. The idea of suspension of fundamental right was taken from German Constitution, and the idea of fundamental right has been taken from the United States of America. Okay, then from the Japanese Constitution we have taken this idea of procedure established by law. We saw that there is rule of law. Everything must be under the legal system that has been provided. Okay, so law is the supreme thing. So there must be a procedure by which the law must be enforced. So if any authority is not following that procedure, the court can say that the procedure has not been followed, and therefore the act becomes null. So procedure established by law. This is the idea that has been taken from the Japanese constitution. Procedure established by law can be contrasted by the term due process of law. So that we will be discussing later on. But this procedure established by law has been taken from the Japanese constitution. Likewise, from the South African constitution, the idea of amendment of the constitution has been taken. We saw that constitution is a living document, it is an organic document. Why? Because with the change in times, the change in circumstances, the parliament amends the constitution to keep it relevant for the prevalent time. Otherwise it may become irrelevant. If there is no procedure for amendment, then the constitution would become irrelevant. Okay, so to keep its relevancy with respect to the prevailing times, amendment is important. But amendment cannot be arbitrary. There must be a procedure. That procedure is given in article 368 of the constitution, and that idea has been taken from the South African constitution. Okay, then likewise the idea of election of the Rajya Sabha members, how the Rajya Sabha members are elected, this has also been taken from the South African constitution. So this becomes important for us to understand and know which section of the constitution has been taken from which source. From the Canada, we have taken this idea of a strong center with residuary powers. See, the center in India is very strong compared to the states. Why? Because it can impose emergency, it can impose directions. So there are various ways which the constitution provides by which the center can assume supremacy over the states. Okay, under certain circumstances, of course, not always. So this residuary power means we have talked about three lists: union list, the articles in which are to be under the jurisdiction of parliament; state list, the items in which the law can be made by state legislature; and the concurrent list, the items under which comes under the jurisdiction of both parliament and state legislatures. Now if certain items remain that are not placed in any one of these three lists, they become residuary items. So whom do they go to? Do they go to the center or the states? The constitution says that by default they would be going to the center. So the center becomes strong because it has got power over union list. There are more number of items in union list. It has got power over the items in concurrent list as well. And though it does not have power over the items in the state list, yet if there is any item which is not mentioned in any one of these three lists, that residuary item will be under the jurisdiction of the center, that is the parliament. So there is a strong center with residuary powers. This idea has been taken from the Constitution of Canada. Then advisory jurisdiction of the Supreme Court. Supreme Court has got three jurisdictions. One is the original, one is the appellate, and one is this advisory. Appellate, we all know, if we are not satisfied with the decision of the high court and the lower courts, then appeal can be made to the higher court. Then original jurisdiction means if there is a dispute between union and the states, then such disputes are to be resolved by the Supreme Court of India. The constitution says that you have got original jurisdiction over these aspects. You have got appellate jurisdiction over the judgments of the lower courts, high courts. Then you have got advisory jurisdiction. This is what the constitution says about Supreme Court. The advisory jurisdiction means the Supreme Court has got the authority to give advice to the executive, that is the President of India can ask for advice to the Supreme Court under Article 143. And the Supreme Court In such situation, if the president demands for an advice, it can give the advice to the president, or by way of president to the government of the nation. Okay, so this advisory jurisdiction finds its place in the Constitution of India, and it has been taken from the Canadian Constitution. Likewise, the appointment of state governors by the center. This idea of appointing of the state governors by the center, this has come from the Canadian Constitution. We saw that in Government of India Act 1935 also the office of the governor was provided for. The Indian Constitution adopted that office. Now how to appoint a governor in that office, that procedure comes from the Canadian Constitution. Clear? Okay, so we already saw that the philosophical part, directive principle of state policies, they came from the Irish Constitution. And how should the directive principle of state policies be? The idea has also been taken from the instruments of instructions, okay, which have been sourced from the 1935 Act, Government of India Act. Okay, so DPSPs come from the Irish Constitution, and DPSPs also have their source in the instruments of instructions. I'm sorry. Then the presidential election, how the president is elected. There is an elaborate mechanism of how to give vote to the president. It's an indirect election, but because he is elected, we become republic also. Okay, so this idea of republic has come from the French Constitution, but the method in which the president is elected, that has come from the Constitution of Ireland. The nomination of the members of Rajya Sabha, we saw that how the members of the Rajya Sabha will be elected, that has been taken from the Constitution of South Africa. How the Rajya Sabha members will be nominated by the President of India, that nomination procedure has been taken from the Irish Constitution. Okay, so Irish Constitution is important because it gives us DPSPs, because it gives us the presidential elections method. Then nomination of the members. Nomination of the members means there are certain 12 members of the Rajya Sabha who are nominated directly by the president. So that comes from the Irish Constitution. So all these things is to be studied in detail while studying the Constitution of India. Then what has been sourced from the Australian Constitution? See, there are the Indian Constitution has taken different ideas from various constitutions of the world. So from Australia, it has taken the idea of concurrent list. We already saw in the federal scheme, there are three lists: union, center, the union list, the state list, and the concurrent list. Concurrent list is the one in which there are items over which both the parliament can make law and the state legislature can also make law. So this idea of concurrent list has come from the Australian Constitution. Australian Constitution also provides for freedom of trade, commerce, and intercourse. So we have the freedom to practice trade, to practice commerce, throughout India. So in Article 301, this is dealt. Then the idea of joint sitting of the two houses of the parliament. The two houses of the parliament are Lok Sabha and Rajya Sabha. So whenever a bill has to be passed, it must be passed in both Lok Sabha and Rajya Sabha. But there can be a situation when the bill is passed in the Lok Sabha but not in the Rajya Sabha. Okay, or vice versa. In such case, there is a provision for joint sitting of the two houses. It means both the members of the Lok Sabha and the Rajya Sabha, they will sit together, and then there will be voting, and out of that, that matter will be resolved. So in case of a deadlock, joint sitting has been provided by the Constitution of India under certain circumstances, not for all the bills. Okay, for but certain bills there can be joint sitting, and this idea has come from the Australian Constitution. So we have seen that this Constitution of India has is sourced many things from different constitutions. So that is the so far we have discussed the salient features of the Indian Constitution. We have seen what is the Constitution, we have seen what the Constitution expresses, we have seen the commencement of the Constitution was from 26 January 1950, and we have seen the various sources from which the Constitution of India has derived different articles, different principles. Okay, so this is the thing that we must know about the Constitution of India. For many questions in different examinations can be framed from that part. Okay, now let us discuss about the nature of the Constitution. Okay. So while discussing nature of the Constitution, we will be broadly looking at these questions: whether the Indian Constitution is federal or unitary. What is federal? What is unitary? That we will be looking at. Whether the Constitution of India is flexible or it is rigid. Whether the Constitution adopts parliamentary form of government or presidential form of government. We already have seen that we have taken parliamentary form of government from the Constitution of United Kingdom. Okay, then whether there is parliamentary sovereignty, means is the parliament sovereign body in India or is the judiciary sovereign body in India. We saw that judiciary is independent, but is it sovereign? Is it supreme over other organs, or is the parliament sovereign in India? So if we answer to these questions, we will be knowing about the nature of the Constitution of India. So let us try to answer these questions. But these are the features that we find in the Constitution of India. Broadly, we see that Indian Constitution is a written constitution, no doubt about it. There are more than 469 articles now, with many parts and 12 schedules. Then the Constitution is supreme. Why? Because it is fundamental law of the land, and all the other land laws are derived from the Constitution of India. There is a single constitution. It is not that a state has got its own constitution. There is only one constitution for India, and that is applicable to the center as well as all the states. Now, even to the state of Jammu and Kashmir, single constitution is applicable. There is bicameralism, means there are two houses in the parliament, Lok Sabha and Rajya Sabha. Likewise, in 5 states, there are legislative assemblies and legislative councils also. Then there is division of power between different organs of the state, between the legislature, legislative organ, executive organ, and the judicial organ. Parliament, ministers, and judiciary. All these are three organs of the state, and they have their own sphere of activities. They are all independent. There is division of power. Then there is a strong center. Why? Because during emergency, the center becomes very strong, and there are many provisions in the Constitution that make our center powerful over the states. There are emergency provisions: national emergency, state emergency, financial emergency. The Constitution is rigid, means it is not easy to amend the Constitution. But at the same time, we see that over these 50-60 years, from 1950 to 2020, more than 100 times the Constitution has been amended. If it had not been flexible, there would not have been so many amendments within this span of time. Okay, so it is both rigid as well as flexible, which we must determine to what extent it is rigid and to what extent it is flexible. But these terms are related to the power of amendment. Then there is independent judiciary. Why? Because it is not subordinate to legislature or executive. It is in its own right. It is independent. There is integrated judiciary. Why? Because administratively the Supreme Court is the apex court. It has got administrative control over all the high courts in the different states, and the High Court has got power over the states which are subordinate to it within its jurisdiction. Some of the high courts have got jurisdiction over not only the states but also adjoining union territories. So Supreme Court, high courts, and the subordinate courts. So likewise, there is an organic administrative linkage that makes our judiciary integrated. Then there is two government, means government at the center and government in the state. So we have got this dual polity, means two governments, one at the center, one in the state. So now we saw that there is bicameralism at the centers. There is Lok Sabha and there is Rajya Sabha. Rajya Sabha is meant for representing the states. Okay. So Rajya Sabha is meant to represent the states. But what happens is that all the states, according to the population, they have been given representation in the Rajya Sabha. In America, all the states have got equal number of representatives. Whether you are big or small, you will nominate only two people, two persons in America. But in India, in the Rajya Sabha, different states, they give a different number of representations. So there is unequal representation in the states in Rajya Sabha. The constitution has provided a schedule wherein it is mentioned which state will have how many number of representatives in the Rajya Sabha. I think it's in the fourth schedule. Then appointment of the governor by the center. You must remember from the constitution of which country this appointment of the governor by the center aspects has been taken. Okay, we have just seen it in the previous slide. Then residual power is with the center. This has also been taken from some constitution of some country. You must recollect it. We have just seen it. This, then there is single citizenship. Then there is single election commission for the entire India. There are state election commissions, but election commission of the central election commission, that is the supreme. Okay, it has got authority over the election of entire India. Then there is all India services, wherein we have got the office of Indian administrative services, Indian police services, Indian forest services. They are all India services. So these are the features we find in the Constitution of India. Very well. Now if we bifurcate these features under the category of whether they are federal or unitary, we will be answering this question of whether our constitution is federal in nature or unitary in nature. So let us try this exercise. Let us put this under different heads. So we see that written constitution is a feature of federal constitution. Why? Because when there are centers and when there is a center and when there are many provinces, many states, then there must be coordination between center and state. Constitution is a document that provides for coordination among the different units. It provides for national identity. So what relation should be there between state and the center? That can be achieved through a written constitution. If things are written in crystal clear manner, that there must be such and such power to the center, such and such power to the state, and what will happen in case of conflicts, that things are codified in the constitution if it is written. Therefore it is a federal feature. The written constitution is also supreme. Okay, because if it is not supreme, then the parliament can change the laws every time, so it will not be good for working of center and states together. Therefore constitution is the supreme authority in federal countries. So we have a written constitution, our constitution is supreme, so we qualify for being federal in nature. But at the same time we have this single constitution. The states do not have constitution of their own. That this aspect goes against the federal feature. In United States of America, every state has got its own constitution, and there is also a constitution for the entire United States at the center. So that is more of a classical federal state. The United States is considered to be a classical federal states. But this feature of ours, that is, we are having single constitution, that goes against the federal feature. So we have a blend of both. We have these features which are federal, but at the same time we have this feature which is unitary. In India, we have got both these features. So we say that it is a blend of federal as well as unitary feature. Then there is bicameralism, there is Lok Sabha and there is Rajya Sabha at the center. But what happens is that in Rajya Sabha, all the states are not given equal representation. We have got unequal representation of states. Some states have got only 2 representations. Some states have got 40 representatives in the Rajya Sabha. So the states have been represented in proportion to their population. But in America, all the states of whatever size, they will be having only 2 representatives. So that is considered to be a federal feature, bicameralism. But this makes us unitary as well. So what we see is that in every federal feature, there is something that goes against the classical federal ethos. So we have introduced some unitary element in the broad federal feature. Broadly we are federal, but we have introduced some unitary features within it. So we are not totally federal, we are not totally unitary. There is division of power between different organs of states, legislature, judiciary and executive. But at the same time, we have given more power to the center. We have given emergency powers in which the center becomes so powerful that it can overrule the laws made by state. Then there is rigidity of the constitution. We saw that if the constitution is rigid, there will be crystal clear laws to ensure coordination between different units. But at the same time, we see that there is flexibility. Why? Because rigidity of constitution means amendments cannot take place easily. There are certain things in constitution which cannot be amended, therefore it is rigid. But at the same time, there are many features which can be easily amended, therefore it is flexible. So here again there is a blend of rigidity and flexibility. Okay, likewise we have got independent judiciary, but at the same time we have got integrated judiciary. Integrated judiciary means Supreme Court at the apex, it becomes a unitary feature for the entire nation. Supreme Court will be the apex judicial authority, that becomes a unitary feature. Then we have got 2 governments. This is a federal feature, center as well as states. But then this feature of appointment of the governor by the center, it becomes a unitary feature. Why? Because center has got more power. By the office of governor, it can exercise more power over the states. The governor can exercise his power in such a way that he can overrule the laws made by the state, and there is always a conflict between the state governments and the office of the governor. Then these features are altogether unitary. There is all India services, means the uh, officers of these services, they will have their jurisdiction over the entire India. Residual power is with the center. This becomes a unitary feature. There is single citizenship. This is also a unitary feature. There is single election commission. So all these feature. Likewise, there is also a single integrated office of comptroller and auditor general. So all these features go against the idea of federalism. In federalism, the states have enormous powers within themselves. But in India, the states have powers, but the center becomes more powerful under certain situations. Therefore, though we have got many federal features, but we have got certain features which are unitary in nature, and therefore Indian constitution is not totally federal nor totally unitary. It is a blend of both unitary and federal features, and therefore these thinkers, they have given different names to the Indian constitution's nature. This Casey Weir, he says that Indian constitution is quasi-federal in nature. Maurice Jones says that it is a bargaining federation between center and states. There is a bargaining. Granville Austin, he says that the Indian nature of the Indian constitution is of cooperative federalism, cooperation between center and state. Niti Aayog is a body that has been formulated to ensure that there is cooperative federalism. Then federation with a centralizing tendency. This is what Ivor Jennings, a political scientist, he says that Indian constitution is such that there is federation, no doubt, but there is a centralizing tendency. Article 1 of the Indian Constitution says that India is a union of states. This is the word which is used in the Constitution. It is not said that India is a federal entity. It is said that India is a union of states. Then the term federation is nowhere used in the Constitution of India. So these are the aspects which we must know while answering the question whether Indian constitution is federal in nature or unitary in nature. It is neither federal nor unitary in toto. It is a kind of quasi-federal or a blend of federal and unitary feature is found in the Constitution of India. Whether it is parliamentary or whether it is presidential form of government that is followed in India, and the answer is from United Kingdom we have um, inherited, we can say, this parliamentary feature. There are nominal executives and there are real executives. Real executives are those who yield power, like the prime minister and the ministers. They have the real power to make law. But nominal executives are those like presidents, who is there as head of the state. The entire machinery works under his name, but then he doesn't have the real power. The prime minister and the executive, the cabinet ministers, whatever decision they take, the president has to follow their advice. This is the condition imposed on the president. Likewise, at the center, in the state, there is governor and there are cabinet and chief minister. In United Kingdom, there is monarchy, but the monarch there, the queen there, is nominal head, and the real power is with the parliament, the ministers. So nominal executive as well as real executives, both these executives are present in parliamentary form of government in India as well as in United Kingdom. There is cooperation and there is coordination between the legislative and the executive organ of the state. While legislative organ means parliament or the state legislature, executive organ means the ministers. Ministers are the temporary executives, we can say, because for 5 years they come and after 5 years they have to leave their office. On the other hand, the administrators, the officers, they are permanent executives. Okay, but these ministers and administrators, they come under this broad term of executive. There is a cooperation and there is coordination between parliament and executive. Why? Because these ministers, they come from the parliament. There is a fusion between legislature and executive. Ministers, they come from the parliament. Minister has to be elected. He has to be a member of Lok Sabha or Rajya Sabha. If he is not, then he has to become one within 6 years of 6 months of his appointment. That is the condition. He has to be a member of either Lok Sabha or Rajya Sabha. So there is a coordination, there is cooperation between legislature and executive organ of the state. Majority party rule. This is an aspect of parliamentary form of government. That party which has got majority of the elected representatives will form the government. Then there is collective responsibility. It means that in Article 74 it is written that if the prime minister resigns, then the entire cabinet will resign. All the ministers automatically resign if the parliament, a prime minister, gives his resignation. So there is collective responsibility. In the Lok Sabha, there will be always questioning of the government. The members of the Lok Sabha and the Rajya Sabha, they will question the government, but particularly in the Lok Sabha there can be a no confidence motion. If the government loses the no confidence motion, then the entire government has to resign. There is collective responsibility, which is a very important aspect of our constitution, and it is a very important aspect of parliamentary form of government. The ministers are collectively responsible for their actions. Ministers in the legislature, we already saw there is a fusion between legislature and executive. Leadership of the prime minister and chief minister, this is a feature of parliamentary form of government. Then this parliamentary form of government is also called as Westminster model of government. Westminster is the place in United Kingdom where the legislature has its place. So from that this name Westminster model of government has come. So we are having this parliamentary form of government. We are not having presidential form of government, which is followed in United States of America, the features of which will be dealt while discussing it in detail. Now, whether Indian constitution is rigid or flexible, we already saw that this is related to the amendment power. Certain provisions are there which can be amended by special procedure only. It is a very rigid procedure, and if the constitution is written, it becomes rigid. So such provisions make the constitution rigid, but certain provisions are there which can be very easily amended, and they are the flexible provisions. Okay. Article 368 talks about the amendment of the constitution. It says that certain articles or certain things in the constitution cannot be amended easily. There needs to be a special majority of the parliament. Special majority means 2/3 of the majority of the members of each house present and voting. If there are 100 members in the house present and voting, then 2/3 means more than 66 members must vote in favor of that item, then only it will be passed. And at the same time, it must be, that number must be more than total membership of house. We'll see that. Then there is special majority, in which there must be ratification by half of the state. I mean, there are 29 states in India. Then half of the states, means around 15 states, they must ratify. Only then that act will be passed. So these things are make the procedure of amendment very difficult, and thereby they become rigid. Whereas there are other amendments which can be only effected by simple majority. Simple majority means only 50% of present and voting. If there are 100 people present and voting, if 51 people vote in favor of a law, it becomes an act, like it will be passed. So if a bill is passed by simple majority, if any amendment bill is passed by simple majority, the procedure is flexible. If it requires special majority and special majority along with ratification by half of the states, then the procedure becomes rigid, difficult. So there are both the procedures which are given in the constitution, and therefore it is also a blend of rigidity as well as flexibility. See, simple majority means more than 50% of members present and voting. Means though the strength of the house may be 535, this may be the strength of the house, but on that particular day, say only 200 people are present, and they are also voting. So only 50% means 101 votes, if they give in favor of a bill, that will be passed. This is simple majority. Absolute means more than 50% of the total strength. It means that if there are 535 members in the house, no matter how many people are present there, but 50% of 535, that becomes absolute majority. Effective majority means 50% of the effective strength. What is effective strength? total membership, for example 535, minus vacancies, certain be it because of death or because of resignation or because of removal, there can be vacancies. So say if 35 MPs are vacant, the places of 35 MPs are vacant, then effective strength becomes 500. So 50% of that means 250 plus 1, that will become effective majority. Then special majority means two-thirds of the members present and voting. If there are 200 members present and voting, then two-thirds of this 200 will form the special majority. But this number must be more than 50% of total membership, means it must be more than 50% of 535 in Lok Sabha. Okay, this value must be more than 50% of 535 in the Lok Sabha, for example. And certain things which relate to the federal aspects, they not only require the special majority, but they also require ratification by half of the total states. Means if there are 29 states, then half of the total states, means minimum 15 states must also in their legislative assembly ratify that particular bill which has been passed by special majority in the parliament. Then only it will become passed, or it will go for to the president for his ratification. So these are the different majorities that are followed while amending the constitution of India, and therefore the special majority make it rigid, and this absolute majority is also makes it rigid, and certain things that can be amended easily by only 50% of members present and voting, that makes it flexible. So Indian constitution is a synthesis of both sovereignty of the parliament. Parliament can amend the constitution, therefore we can say that parliament is sovereign. But at the same time, there is judicial supremacy. Why? Because the Supreme Court can declare parliamentary law as unconstitutional and void by the power of judicial review. Therefore, we can say that there is also judicial supremacy. So no one is supreme. Everywhere there is check and balance. If the parliament makes law against the fundamental rights, for example, the judiciary can say that that law is null and void. So neither the parliament is totally sovereign like in United Kingdom, nor is the judiciary totally supreme like in the United States. We have a synthesis of both. So therefore, in conclusion, we can say that we are a blend of federal and unitary features. We are a blend of flexible and rigid features, and we follow this parliamentary form of government. We have a head of state which is elected, and therefore we are a republic. And then we have a synthesis of parliamentary sovereignty and judicial supremacy. So we have in this lecture dealt in elaborate terms the salient, what is constitution, the salient features of the constitution, and the nature of the constitution. So let us rest for today, and we'll be having such more videos on the polity aspects which will help you in preparing for different examinations. Okay, so as an exercise, you can pause and give an answer to these questions. Which one of the following is the feature common to both Indian and the American Federation? Okay. The Indian parliamentary system is different from British. How? You can give an answer. Match the following. We have taken these features from which country? Fundamental rights from which country? Parliamentary system from which country? Emergency provision from which country? DPSPs from which country? You can post your answers. Likewise, this is the match the following for you. So that we come to an end.